broker liability, section 14. So I am the broker. So this has to do with me, right? So professional advised broker liability. The broker advises the buyer and seller to verify property condition. Yes, I am. Square footage and all other facts and representations made pursuant to this contract, and to consult appropriate professionals for legal, tax, environmental, and others specialized advice. Buyer agrees to rely solely on seller, professional inspectors, governmental agencies for verification of property condition, square footage, and facts that materially affect property value, and not on the representations of the broker. So this is a paragraph, very long paragraph, that is releasing liability from the broker, okay, as far as shortages of area, as we call it in Texas. So in Florida, advise your buyer to do their research as far as property conditions, square footage, all these things. Don't promise something and say, oh, it's it's without any sort of proof. You have to do your inspections. The buyer has to do due diligence. So there's my speech on that. Okay, section 15, default, also referring to breach of contract. So this is what this paragraph is all about. Buyer default. This is about seller default. Basically, you need to understand what will constitute a default, and then what happens to your either buyer or seller, whichever one. You need to understand, you need to be counseling them about this, because part of this as well is that this paragraph will survive closing or termination of this contract. So it's very important to understand that if the seller fails or neglects or refuses to perform, they could seek damages. The other party can seek damages. Okay, this is the section that you need to be explaining to both parties to say, look, you could get sued if you don't adhere to the policies in this contract. Because of that, I would say, I am not an attorney. Realtors and brokers are not attorneys, okay? They're not CPAs. If you need to have this verified, have this, explained to you in legal terms, please give it to your attorney. Have your attorney help you with this, because you want to make sure that the buyer is going in with eyes wide open as to what could happen after closing. Same with the seller. It's really important. Section 16. We are already through to page 7 of the contract. So dispute resolution. So this is how we do it, right? Mediation. Realtors do mediation. So unresolved controversies, claims, and other matters in question between the buyer and the seller arising out of this contract will be settled as follows. Okay, buyer and seller will have 10 days after the date conflicting demands for the deposit are made to attempt to resolve dispute, failing which buyer and seller shall submit such dispute to mediation. Mediation is what we do, okay, and it usually starts at the ground level, and then it goes all the way up. So when a buyer or a seller will complain against each other, or will complain against the agents involved or the brokers involved, okay, it's through mediation. That's how it's resolved. And there's all kinds of things that could happen depending on what was found. So it's important to have all of your T's crossed and your I's dotted. Section 17, attorney's fees costs. So the parties will split equally any mediation fee incurred. Okay, this has to do with mediation. Buyer waiver of claims. So to the extent permitted by law. The buyer waives any claims against the seller and against any real estate licensee involved in the negotiation of this contract for any damage or defects pertaining to the physical condition of the property that may exist at closing and be subsequently discovered by the buyer. Okay, so this provision does not relieve the seller's obligation to comply. The standard X shall survive closing.